are watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.
Good morning and welcome to the Florida Supreme Court. The first item on the court's agenda is the inquiry concerning Judge Angela Dempsey. Judge Dempsey, if you would come to the podium. Judge Dempsey, your appearance before the court today marks a sad occasion, saddest of all for the public we serve. The effectiveness of our judiciary ultimately rests on the trust and confidence reposed in judges by the people. You are here today as a result of an ethical failure that has damaged the public's trust and confidence. Because no one can undo what you have done, we have commanded you to appear before us to receive a reprimand that is being broadcast throughout the state. This is not a task I enjoy, but certainly one that we as a court regard as vitally necessary. It is one way we can at least assure the public that we take this matter very seriously and that we will not hesitate to discipline judges such as you in a most public way. You have been found guilty of violating Canon 7 of the Code of Judicial Conduct. The charges filed against you arise from your 2008 campaign for the circuit judgeship in the Second Judicial Circuit, which you now hold. You employed the services of a political consultant for whose campaign conduct you are responsible under Canon 7A3B of the Code of Judicial Conduct as it existed in 2008. In pertinent part, the provision of the code requires all candidates for judicial office to prohibit employees or others serving at their pleasure from doing anything that the candidate is forbidden to do. According to your own admissions, the consultant prepared 2 commercials and uploaded them to the social media video sharing site, YouTube. A link to one of the YouTube videos used the phrase, "Re-elect Angela Dempsey." In point of fact, you had never been previously elected to the office at that point. Instead, you had been appointed in 2005. To your credit, you have accepted full responsibility for the consultant's actions, even though you had no knowledge about the placement on YouTube. In that sense, this case stands as a warning to all future Florida judicial candidates. You will be held responsible and accountable for the actions of your campaign consultants. including the way they choose to use new technology like the social media. Based on this information, the Judicial Qualifications Commission concluded, and you have stipulated, that this conduct violated Canon 7A 3D2 of the Code of Judicial Conduct. That provision prohibited you, in pertinent part, from misrepresenting your own qualifications or any other fact about yourself during your campaign. In addition, the Judicial Qualifications Commission found that you have agreed by stipulation that you misled the public by claiming in a mailer to have 20 years of legal experience. In fact, you were not admitted to the practice of law until 1994, and the 20-year calculation included the time when you were in law school. This constituted another violation of Canon 7A 3D2, as it existed in 2008. For these violations, you must be and are hereby reprimanded. Finally, Judge Dempsey, we encourage you to review the prior disciplinary cases from this court from time to time. You will find that in a number of these cases involved only a single breach of ethics during a judge's career, with none that followed afterwards. We hope that that will be the case here. You will also find a far fewer number of cases in which judges did not learn from their mistakes and committed yet another violation. We advise you to remember that our prior cases have consistently held a second ethical breach by a judge will be reviewed far more harshly. Judge Dempsey, your public reprimand is concluded and you are free to leave. The next matter on the court's agenda is the Miccosukee Tribe of Indians versus the South Florida Water Management District. Let me see if I understand what we're doing here. We're going to have a 15-minute argument from one petitioner, then a 5-minute argument for the other petitioner, and then the appellees will have 3 people who are doing their arguments? Okay.
Madam Chief Justice Joe Clark, if we can indicate Mr. Leighton will be speaking for 15 minutes, and I'll be doing a rebuttal for 5.
Oh, you're doing a rebuttal for 5, not okay.
Thank you.
All right. You may proceed.
May it please the court, Dexter Leighton, representing the Miccosukee Tribe of Indians. Your Honors, this sugar buyout, which threatens to do such damage to the Miccosukee Tribe's Everglades by diverting funds from ongoing restoration projects, should be rejected.
Let's start here with, you know that judicial review of bond validation cases is limited to 3 inquiries. So if we could make sure we keep our argument focused on those 3 items, we really would appreciate it.
Yes, Your Honor. With respect to those 3 items, it should be rejected for a number of reasons associated with the established requirements for a public purpose and public benefit derived from the funds raised, and for a number of principles associated with the requirement for public participation in the Florida Constitution, the referendum requirement. With respect to the public benefits with the funds raised, the South Florida Water Management District fails to identify with any specificity a plan or project that they're going to carry out with the funds raised.
Well, I think in general, the project is the Everglades restoration, correct?
That's correct, Your Honor.
And that at some point after the acquisition of this land, they plan to build some facilities to I'm not sure exactly how you clean up the Everglades, but this is supposed to be some water kind of recycling or other projects. I think that was laid out in what the district presented. So why isn't that a public purpose?
Well, Your Honor, that's all they lay out. They do nothing more than parrot the statute. They say Everglades restoration. They do not identify specific projects that will be done. The summary of benefits remained exactly the same when they were going to buy 187,000 acres, when it was cut to 182,000 acres, and now it's the same when it's at 73,000 acres.
Could you explain whether during the litigation, the initial request was for validation of the bonds for the whole 183,000 acres, correct? Was that, did it change sometime during the
Yes,
litigation?
Your Honor. Initially, it was 187,000 acres, including railroads and all of their capital equipment. Then it got changed to 180,000 acres, rounded off. And then in May, it got changed, in 2009, changed to 73,000 acres.
So are you saying the petition never changed as to what the...
No, it did not, Your Honor. They supplemented it, but they supplemented it not with a change of the public purpose. The summary of benefits, without any identified specific project, remained the same throughout the entire proceedings.
Your objection was the same, whether it was the whole 187,000 or the 73,000. Your position is that without a plan in place as to exactly how they were going to use this land for the Everglades restoration, that it cannot serve a public purpose?
Well, it is, Your Honor. The Florida Supreme Court has said repeatedly, for example, in Suwannee County Development Authority, that although specific, construction plans are needed, it says that petitioners for validation of bonds should set forth in reasonable detail the purpose or purposes which will be accomplished with the proceeds, and it says it requires sufficiently detailed explanation to enable the public to evaluate.
Well, you said it was, we've said it repeatedly. Actually, we said it, the Suwannee County case was in 1960, and in that case, they were going to lease the property back to private developers and had no plan as to what they were going to do with the land. You're not comparing what's happening here. I mean, there's no suggestion that the South Water Management District is going to use this to lease it back to sugar and have them build some more sugar plants, manufacturing plants on the site. I mean, there's nothing like that in this case, is there?
Well, Your Honor, all they're going to do is buy land and lease it back to sugar. That's all they're going to do with $536 million. They cannot do anything more. They have no specified project that they will build later.
Well, you agree that you got to have the land first before you can do something with it, and there's some value in having this land south of Lake Okeechobee, as the evidence was supported, in order to begin the restoration efforts coming south from Lake Okeechobee. That's part of their plan. So you have to have the land first before you can go to the next step, don't you?
Well, yes, Your Honor, but if you're going to require my children to be paying for bonds 28 and 30 years from now, then you have to have more, according to the Florida Supreme Court and the Constitution, than a pie-in-the-sky parroting of the statute. They have no further plan than exactly what the statute says, Everglades restoration. They have no identifiable project that they're going to build. All they're going to do with $536 million is purchase the land, and because they can't do anything with it, immediately lease it back to U.S. Sugar. And with...
What bothers me about your argument here is it seems to me that what you're really saying is that unless a governmental unit or an entity that has the authority to have these kinds of bonds has all the money to do a complete project, that they cannot do this by buying it in bits and pieces.
Well, Your Honor...
Why should we say that?
Depending on the characterization of that, I would proffer to you that that's what the Florida Supreme Court has said and has said repeatedly. If you're buying 5 acres on which you can build a school, and you have a plan later to buy another 5 acres for another school, that school stands alone. That first one stands alone. But if you're going to do what they did in Frankenmuth, or they're going to do here, buy 73,000 acres, exhaust their financial capability, lease it immediately back to U.S. Sugar under terms that say you can't get 20,000 of the citrus land for 20 years, you can get 10,000 of it within the first 10 years, you can get another 10,000 between the 10th and 20th year, and in no case, forget those rights, can you ever get any of the land, the waterman's district ever get any of it, unless they develop in the future, because they don't have it now, in the future, a specific plan, fully funded, and then under the lease to U.S. Sugar. See, U.S. Sugar knows what it's doing. U.S. Sugar says, until you have a specific plan, fully funded, you claim you bought our land, but we're entitled to lease it from now till the cows come home, 20, 30, 40 years, until you develop a new specific plan and until you fully fund it. Now, that's what the public should be upset about. U.S. Sugar is going to get the benefit of the district not having a specific plan and not having funds to build it, and it's just going to sit on the land. And in fact, the land abandoned is worse than not abandoned.
Let me ask you this. How specific do you need to have the plans? Because as I have read this, it seems to me that they are saying that we're going to acquire this land, and then we are going to build these facilities that are going to do whatever these facilities do with the water and to help restore the Everglades. So how specific does the plan have to be? Do we have to have every detail outlined before we can say, yes, you can begin to acquire this land, which seems to me to have some benefit? U.S. Sugar certainly can't, or can they, at this point, now sell the land to someone else who might build something on it, and then the land may in the future cost the water management district even more money. I mean, so how specific and detailed do you have to be before you can get started on this kind of project?
Well, the court would say, and has said in the past, sufficient specificity, not exact plans, but sufficient specificity so the public can evaluate the proposed project. I offer to your honors, there is no proposed project. If you point to a piece of land in the 73,000 acres, they have no clue what they're going to build on it. They commit to nothing to build on it. In fact, they promise U.S. Sugar that until we develop further plans, you keep the land from now for a century. So if U.S. Sugar benefits from a lease that says, right now, you don't know what you're going to do, Water Management District, if you ever develop the plan and fully fund it, then you can take the land from us that you allegedly developed, but not 20,000 of the acres you can't get for 20 years, 10th you can't get for 10 years.
One of the questions I have, and I think you addressed it in your briefs, is first of all, is this part of the project that includes $50 million as an option for the sale of or the purchase of the additional acreage? Are you separately attacking that part of the bond validation?
Yes, Your Honor. We believe that with respect to the public purpose from the funds raised, the lack of specificity is a problem. We believe that the only what can be done with the funds raised is only buy land, and we believe only buying land creates only a direct and immediate use, which is the Orange County industrial case for private individuals. And in addition, the option, they're paying $50 million or $40 million.
But what the judge did below is, because there was some question about how much of the bond amount should be validated, that could be severed from the bond validation, could it not? In other words, if $50 million is for an option that someone says that's not lacks specificity, wouldn't that be the remedy as opposed to setting aside?
Well, if I understand the question, Your Honor, if the $50 million, as is the fact, buys nothing, they'll have to float new bonds sometime in the future, and right now they can't even do that because it's under their 20% cap. It's illegal to float enough future bonds to buy the land that the option will be for, and Judge Heffley found no public purpose for this other 83,000 acres.
We didn't find out. He found that there wasn't sufficient specificity.
Specificity, well,
it's a pretty big difference. He didn't say there wasn't a public purpose.
Well, you know, some of that land, I proffer again to Your Honor, if you're going to buy that land and lease it back to U.S. Sugar and let them keep it for a century, The Miccosukee Tribe would say there is no public purpose on that. The tribe doesn't believe in I'm from the government, trust me. They've been damaged by I'm from the government, trust me for centuries. They want to know what the plan is, as does the public. Now, with respect to the specific question about the option, it would appear under some approaches to the law that you could strike $50 million. But the problem is these guys are going to stand up and say, if I may speak colloquially for the gentleman, are going to say that the option was free. I mean, it's a silly statement, but they're going to say that because, and what is the price of the option? The appraisals were for $480-some million, but they want to bail these guys out for $536, so they had to say an option for 3 years that we know demonstrably is illegal to float bonds to exercise, but they need another $50 million, or somebody needs another $50 million. But so we say $50 million, but they claim nothing. It could be $68 million.
The answer is it could be severed. Could not.
Yes, Your Honor, conceptually, but the problem would be that you don't know the exact amount of the option. It's worth something. They're going to cash the check. U.S. Sugar is going to cash a check, so it's money. But exactly how much you would sever would be a difficult.
Now, when we
Well,
talk
about, I'm sorry. I thought you said it was worth $68 million or $50 million.
Well, the reason
one of those figures, it seems to me, would be what you would use in order to sever, even though.
Well, yes, perhaps, Your
why
Honor.
isn't that the appropriate?
The joint appendix, page 11901, has the Water Management District's charts that show an appraisal of the land at $486 million. They're paying $536, and they claim an appraiser said under certain circumstances, if you could rock mine that land and all kinds of other stuff, that that land, an option on it might be worth $68 million. So they claim they got a really good deal. Something worth $68 million they paid $50 million for. Of course, legally they can't exercise the option because they don't have the authority within their legislative cap.
You're talking about, what I want to ask you is the effect of Florida Statute 373.1391, which says that the legislature has declared that it is necessary for the public health and welfare that water and water-related resources be conserved, and that the acquisition of real property for this objective shall constitute a public purpose for which public funds may be expended. We would know if we were dealing with beach restoration that purchase of oceanfront beach land serves a public purpose, because then you cannot have development on it. Within the Everglades, isn't the purchase of a large section of property that will then not be able to be used for further development, for sugar production, doesn't that serve the purpose of the Everglades, of having undeveloped land within the area, aside from the issue of the water treatment?
Well, working back, Madam Justice, with respect to taking out of sugar production, that's not true. It's immediately leased back, and 20,000 acres at least stays in production for 20 years. But furthermore...
But they have very strict restrictions on how that land is to be used.
Well, they have that legal authority today. I mean, this is an agency that says we're a public agency with public regulatory authority, but we got to go buy somebody in order to regulate them. I mean, that's silly. They just abdicate their responsibilities and say the public has to float bonds for $500 million to get the authority to regulate those guys. I mean, I've read the state constitution. They can regulate them today, and they ought to. But with respect to the question of taking the land out of production, it doesn't come out of production. But furthermore, all of their statements of benefits, and I'll conclude with this, let Mr. Clark perhaps address referendum, or maybe it's clear in the briefs. All of their statements say that the public purpose is, in the case of the resolution, it's land and improvements on the land. In the case of their complaint, it's constructing, equipping, and installing equipment on the land. Land purchases alone accomplish nothing. In fact, it's so bad to just purchase land and abandon it that for zero lease cost, they're letting U.S. Sugar come back on the citrus land to maintain the citrus, because if you abandon it, you're worse off. Everything flows off it worse. And I'll conclude. You are into the rebuttal time if you want to make sure. I will then conclude, Your Honor, just with, I'd like to quote one statement from the executive director of the district. Construction was necessary, not land purchase alone. She says, I cannot think of a water restoration project in the world that buying the land by itself is just the project. You have to build on it, and they have no ability to do it. Thank you, Your Honor.
Thank you.
Good morning, and may it please the Court. I'm Maureen Hackett. I'm an assistant state attorney from the 15th Judicial Circuit, and I'm attending this proceeding on behalf of the state of Florida. Also in this courtroom is Michael McAuliffe, the state attorney from the 15th Judicial Circuit from Palm Beach County. The 15th Judicial Circuit is here representing collectively all of the state attorneys in each of the judicial circuits within the district's boundaries that are affected by this bond validation proceeding. These circuits comprise 16 counties. We are a part of this proceeding pursuant to our statutory responsibilities set forth in Section 75.05 of the Florida statutes. Our duty under this statutory sections require us to examine the complaint and to have access to the records of these proceedings and to determine whether the complaint and validation is defective, insufficient, untrue, and not duly authorized. We're here to state that we have performed those functions, and the state is integral to this proceeding, and it's in a unique posture. Neither are we a proponent of this validation proceeding. That is not, in fact, our role. But we are not, after listening to the evidence and after attending all of the proceedings, we are not going to be asserting a defense to this validation proceeding. We believe that our review process is very limited in scope and circumscribed by the same parameters that the court has circumscribed, the trial court that is, as set forth in Strand versus Escambia County. We have looked to determine whether the governing body has the authority to issue the bonds, whether the authorization and obligation complies with all the requirements of law, and to determine if the purpose of the obligation is in fact legal and a public purpose. We believe that there is substantial and competent evidence in this record to support the findings of the trial court and the legal conclusions that the trial court has done. What the record here demonstrates is that there is, in this proceeding, is that there is a belief among all the parties that reclamation and restoration of the Everglades is in fact an important undertaking. The water quality, flood control, environmental protection, and restoration is indeed an important and public process. How this is achieved is clearly at issue here. Our role cannot intrude upon the prerogatives of the governing bodies and the entity, the South Florida Water Management District. We cannot consider the wisdom of the business decisions and the financial judgments that were made. The financial feasibility of this project is beyond our scope of review. We have reviewed the legality and oversight to ensure that it's not contaminated by fraud or illegality. We concur with the findings of the trial court, and we concur that any benefit to private interest in this matter is incidental to the public purpose which is sought to be achieved.
And thank you very much.
Thank you.
Is this yours also?
Good morning. May it please the court. My name is Randy Hannon with the law firm of Bryant Miller Olive, representing the South Florida Water Management District. With me today is Mr. Fred Springer from my firm and Mr. Frank Bartolone from the Water Management District. I'm going to reserve 3 minutes at the end for Mr. Tom Rumberger, representing Audubon. As complicated and as convoluted as the appellates want to make this case, it's very simple. We're buying 73,000 acres of highly valuable land south of Lake Okeechobee and north of the Everglades. It will be used for Everglades restoration and specifically for water treatment and storage.
But is the problem that, well, let me ask you this way. If you had just set out to want to buy the land to sort of take it off the market, like a beach restoration, would that be would the arguments be the same, or is it integral to this project that you've represented in the complaint, that it is going to be used not just as land that is reclaimed, but that it is going to be used for water storage and
treatment. And you mentioned Chapter 373, 139, and I would call you to that, call your attention to that. And it says the acquisition of real property for the objective for the objective of conserving and protecting water and water-related resources is a public purpose. What they would ask you to do is to require the immediate materialization of mature conservation projects at the point in time that you buy the land. And when
don't you have to have a plan in place, because that's what you've represented, that this bond, it's not just for the purchase of land to take it off the market, but it is for the to be used for the next step of water treatment and storage. And if you don't have a plan of how that's going to happen, doesn't that make the initial purchase potentially defective?
Your Honor, I would make a couple of points. Number one, I would ask you to look at the entire statutory scheme of Chapter 373. There's a general agreement among all the parties involved that we need between 800,000 and 1.2 million acres for Everglades restoration. That's what we need. And there's also a general agreement that you use the concept of adaptive management, where science, time, and technology change the process over a point in time. What changed the best methods of restoring the Everglades over a point in time. What they would ask you to do is to say, no, you have to know exactly what you're going to do before you buy the project.
No, I understand. I mean, but this didn't start out as saying, listen, we've got to reclaim, we need to get 800,000 acres, and this is the first step in 800,000 acres. We want to buy all these parcels, and that will be one aspect of restoring the Everglades. It started out with there's going to be 187,000 acres, and we're going to use that for the water storage and treatment south of Lake Okeechobee. And so that's the concern is that the complaint didn't change when the scope of the project changed, and is that within the scope of the court's inquiry?
With all due respect to counsel for the appellants, the complaint did change. We did change it from 181,000 to 73.
Well, then why did the judge actually say at the end that the additional 107,000 acres of the option land didn't serve public purpose?
The complaint did change. Well, we disagree with the lower court judge, but to simplify the issues before this court, we did not appeal on that issue. I would point out to this court from the minute that the district started looking at this, and if you look at the complaint, there's a summary of benefits, an extensive summary of benefits of what you would do with the land. Since the minute they have entered into the contract, the district has undergone an extensive process of looking at various projects throughout this area. They've entered into an extensive process. There have been 11 different configurations presented to the district and in evidence before this court, and actually one presented by New Hope. And the judge specifically found that there were projects for the 73,000 acres here. This is not a Swanee issue. In Swanee, they were, as Justice Thornall said in his concurrence, they were buying land. They didn't know the land. They didn't know the building. They didn't know the project. They didn't know the company that was going into it. They didn't know what the company was going to do. What we're doing here is we're buying land for Everglades restoration.
Mr. Hannon, at one time, did this, the overall plan that we're talking about, envision that the land that is to be the subject of this bond issue was available for transfer, for trade, for other things that then may go toward restoration? Or was that never part of any consideration?
Your Honor, I ask you to help me again.
The land we're talking about, this concept of restoration, is there anything in any of these plans that have been presented that would permit the land to be traded, transferred, in exchange for some other properties? This has nothing like that. This is, I mean, it's there. It's going to be used for this, nothing else. And there are sufficient restrictions on that?
Well, actually, if you read Chapter 373, it wasn't intended that the district just buy land that you may need. In fact, there's a whole statutory scheme for you to be able to surplus property. And that may very well be the case here. We may not
for transfer for some other purpose, though.
We could very well sell some of the land that we buy. Once you decide on an ultimate scheme here, it would then be considered surplus land, which you could sell to another party.
Well, wasn't there actually some contemplation about there was something about 3,000 acres that actually was being used to mollify some of those that might have opposed the deal? Isn't that is that? I know that I read it in the briefs. Now, whether it's in the record, but I know it's there.
I probably would not have used those words.
Well, I was trying to use even a kinder word than they might have used.
There are 3,000 acres that are classified as transition lands in the contract. That the testimony of the executive director was that they would work with the local governments to transfer them to local governments, hopefully for the purpose of water restoration projects. We believe that is allowed under the statutory scheme.
It just says hopefully?
Excuse me?
It says hopefully?
It does say hopefully, but that's what the executive director did say. But we believe under the statutory scheme, if they're surplus properties, they don't have to be transferred just for water restoration purposes.
See, my issue or my question is if, I understand the concept of saying that if you have within this river of grass a huge chunk of land that becomes available, the idea that you as a water management district, it's clearly seems to be within your overall purpose to want to acquire this land for, stop the polluting that is going on,
right.
And to also consider it as for water for the restoration, treatment, and storage. But if you had said to the trial judge, listen, we're not sure if we're going to take this 73,000 acres and we're going to just keep it there, and that's going to be a benefit to the Everglades and within our mission, didn't you represent that you were going to use this property for actually developing the water treatment and storage, which I understand isn't like necessarily, as you said, bricks and mortar, but it could be within the property itself. So does that distinction, does it matter for the bond purposes? Now, it might not have mattered if you had this money on your own. You could have probably purchased it. But for bond purposes, does it matter that you've represented it to be for one particular purpose? And it seems to me that's what Mr. Leighton has been harping on, is that you have no way to really use it for the purpose that you have represented that the land would be used for.
Your Honor,
does that make sense?
I understand. With all due respect to the statements made by Mr. Leighton in his brief, I believe the standard for whether you're using public money or whether you're using bond money is the same. And you buy land here for the objective of water restoration, for water storage and treatment. As you design the plans, as you design the projects, you may have surplus land. This was an agreed upon transaction. We had a buyer and a seller. They would sell us certain lands. And that's what you had to do.
Well, so that's what I'm asking you is that do you say that the South Water Management District has the authority to use its bonding power delegated by the state to buy up land, even if they're not sure which of those properties are going to specifically be used for the more narrow purpose of water treatment and storage?
If it is bought for the objective of water and water-related resources, which it was, and if you look at this...
But that would be true, then, of any of the land that would be within the River of Grass, wouldn't it? I don't know the
I don't know if it would be true. I don't know if it would be true of any of it, but clearly when we're talking about needing 1 million acre-feet of storage, buying this 73,000 acres, it's certainly a public purpose under 373. And so I would say the answer to that is yes.
Well, let me ask you about the surplus. The cases that I've seen that talk about surplus, usually you bought the land and you've done what it is the public purpose, and there's some land left over, and so you get to sell it or use it for another purpose. But it seems to me in this case that you're actually buying this to use it for another purpose as opposed to it just being surplus land at that point.
No, Your Honor. In fact, the trial court judge specifically found that we had specific projects for the 73,000 acres.
Well, I'm talking about the 3,000, basically.
Oh, the
which,
3,000.
I understand as a part of their argument is you're buying that to actually to pay off, I guess, the municipalities who had some quarrels with the acquisition of this land in the first place.
Your Honor, we bought land that U.S. Sugar had for sale, south of the lake and north of the Everglades.
Where does that, I mean, if we're going to speak in terms of logic, then I would assume if we follow that reasoning, that 75% of the land could then be used and sold, transferred, and then if we could use 25% of it, where does that stop, the concept of, we know that we have land in here that we're going to do something else with? Where does that stop? What is criteria that we would look to with regard to that?
Your Honor, I don't know that I can tell you where it would stop, but I would say when you need 1 million acre feet, that 73,000 acres clearly fits within it. And the statutory scheme of leasing...
You're avoiding the question that Justice Quincy
I apologize.
I raised initially, and that is about this land. You referred to it as transition land.
The 3,000 acres.
There's acreage that's involved, and so the question is, I mean, what's the standard? And we're being asked to approve that, and is there a standard? Maybe there's not. Just that question has arisen, and the answer, I respectfully suggest, that, we need 20 million acres doesn't answer that question. I mean, you may need substantially more than this property involves, but if this project contemplates a transfer of most of it to somebody else and as part of the plan, what's the standard? What's the standard?
The standard is in 373-139. The standard is, are you buying land for water treatment and for the objective of water treatment and storage?
That would include, then you can buy another 10 million acres as part of that same purchase.
If
you can say that the purchase of part of it is within that statute, that's what the answer is.
I would not agree that I could say that there would be a point in which you would get outside of the scope of that statute. But I would say here that where you had land for sale and you had a de minimis amount that may be transferred to municipalities fits directly within 373. In fact, there's a specific section in 373 that says you can transfer lands to local governments, and that was covered in our brief.
I believe Justice Poston has a question for you.
Yeah, I'd like to go down two different issues with you, if I may. The first line of questioning has to do with the option raised. Now, their position is, in the sale document, there's $536 million, and you attribute that whole purchase price to the 73,000 acres, right?
We do, Your Honor. In fact, I think if you look at the conclusion on page 34 of the final judgment, I will tell you there's some inconsistency in the judgment. In one place, he says it's an option for $50 million. In the other place, he said the entire purchase price is for land.
But then their argument is, well, there's expert testimony or record evidence indicating that this right to buy has significant value, perhaps $50 million, $65 million, is nowhere allocated in the purchase agreement.
That's purely a business decision. And while they may not like it, for this court to step into the role of the water management district and second guess that decision would be outside the scope of this.
I'm not second guessing the business decision to have an option, but what concerns me is that you raised in your brief saying that there was nothing paid for this option, right?
The option was taken into consideration in determining what to pay for the land.
So, but you've said in your brief, I believe, that there was no separate payment for the option.
That is correct.
The whole amount went to the 73,000 acres.
That is
so
correct.
If there's no payment, how is there consideration for the enforcement of the option? Is it an enforceable part of the contract?
We do believe it's an enforceable part of the contract.
Where is the consideration for it?
The consideration is all taken in, is all part of the overall acquisition, including the acquisition of the land, the option, and the lease back. Clearly, there's consideration here.
Well, if there's issues about the enforceability of the option, does that cause a whole contract to be at issue?
Not at all, Your Honor. Not at all. I don't believe there are any issues about the enforceability of the option, but clearly that could be severed. But I think if you look at the judgment and look at page 34, I believe the judge is clear on that point.
But how could you have a $536 million purchase price allocated to the whole 73,000 acres and have this significant valued asset, which is the option, and have nothing allocated to it?
Because it all went into consideration for what you paid for the land. That's a business decision. It's a business decision of what they paid. What they paid was a business decision of the governing board. It's not a legal decision.
This is not a form over substance type allocation?
No.
So are you basically saying then that you paid more for the land than what you would have paid if there was no option?
I am saying in taking into consideration what they paid for the land, they did include the fact that they did have an option, yes.
Well, the other line of questioning I have for you is the asset substitution for collateral.
Yes, sir.
So as a means to lower the interest rates on the financing, you have the ability to substitute assets in there from the water management district, correct?
Yes, sir.
Is it possible under that scenario to substitute in assets which have been approved by taxpayers, paid from ad valorem taxes, approved by referendum, to have those assets substituted in for this transaction in which the taxpayers will not vote on, subject to collateral on this transaction?
That is possible, but I don't think the fact pattern that you gave me would create a problem.
Why not?
And, Your Honor, I just want to make sure I'm okay on time, because I want to make sure that Mr. Rumberger, and I'm running late here, I want to make sure Mr. Rumberger.
Well, please answer Justice Poston's
thank you.
question, and we'll deal with that.
The fact that you would substitute lands, in fact, there's great testimony from the executive director as the purpose of that, starting on page 2223 of the joint appendix. And that is a very common concept, and if you'll look at section 6.4 of the master lease agreement, there's a provision for the substitution of lands. I would say as long as you did not put land in that had, quote, a non-substitution clause in it, that you would not run afoul of any constitutional issues. The fact that other land had been paid for with ad valorem taxes is irrelevant to the question of whether or not you have the ability to walk away under the lease. And so I do not believe that is a concern. Okay.
Thank you very much.
Thank you very much.
I have a leg that's not working quite so well. May it please the court, my name is Tom Rumberger. I represent the Audubon and its various organizations, and additionally Mr. N.P. Reed, Nathaniel P. Reed, who is a about environmentalist, taxpayer, and citizen. In a brief and general statement, we believe this land acquisition provides the best and last chance for significant Everglades restoration. The acquisition of the land itself has merit, without any thought about the construction per se. The land, the value of the land lies in first taking it out of production, and that would be initially 10,000 acres, and another part of that land is 30,000 acres, which is the referred to citrus land, which will be available immediately and which will provide the cleanup, and all this is in the record, of course, provide the ability to clean up what's called the C-139 basin. The most polluted, the most disgusting, the worst part of the Everglades. That will not require great sums of money, by the record, but will provide the basis for this significant cleanup. In addition, there are 4,000 acres which will lie south of the lake, which provide pump land to place pumps, which prevent then the back pumping, which is a despicable operation engaged in. Yes, ma'am.
These items that you're talking about, are these a part?
Yes, ma'am, they're the part.
The district's plan for the use of this. I mean, you say this is a great way to do it, but is it a part of the district's plan?
Yes, ma'am. It is part of the preliminary plan. It is being discussed by the various stakeholders in a series of meetings and was testified in the court by various officials of the South Florida Water Management District as to what the use of this land will be. In addition, there are 8,000 acres. For example, there are 8,000 acres lying to the southeast of the property, part of the property. That 8,000 acres is available for trade, as Justice Lewis spoke about. Now, what that trade could be, for example, is not giving the land to somebody just to give the land away. That 8,000 acres, for example, could be used for what's as a trade or as a part of providing that the inland port, which has been suggested, will not go into the Everglades area that is blocking restoration, but could be made available, for example, as an addition to the inland port, which is now being proposed. There are other various parts scattered around, all of which have been carefully selected, not just discussed, but carefully selected for use in the Everglades restoration. We would also suggest that the public purpose is very clear and is outlined by the legislature in Chapter 373.016, I believe it is, and combined with 373.139. Restoration in and of itself is an object which is suitable for and designated for public purpose.
Bottom line is you,
yes, ma'am.
On behalf of the environmentalists, vehemently contest this is a sweetheart deal for U.S. Sugar.
Who contests that, ma'am?
You contest that that is what has happened. In other words, you say this is a environmentally positive action.
Absolutely. To my knowledge, every environmental group supports the acquisition of this. I am not familiar with and have some familiarity with all of them, and I am not familiar with any which oppose. We are very, very supportive of the acquisition. We believe that it is an essential part of Everglades restoration, and we believe that that it should be approved by this court. Now, yes, ma'am.
With that, you have used all of the time that has been allotted to you, Mr. Rumberger.
Yes.
We appreciate your appearing before the court to give us
Well,
your
we
views.
appreciate the opportunity, Justice. And we hope that we can, unlike Nero, who fiddled while Rome burned, that we can move this directly to a part where the talk ceases and the restoration commences. Thank you very much.
All right, thank you. Mr. Clark?
Madam Chief Justice, may it please the court. Joe Clark on behalf of New Hope in Okeelana. If I might, Your Honor, I'd like to return first to the question you asked 4 times without getting an answer. That question was, did the petition change when the scope changed? It did not. My understanding, my recollection of the record was the only thing they did was attach the new contract, which reduced it down to 73,000 acres. There was no change in scope, which is significant because when the case was first put on, it was explained how essential all 183,000 acre lines drawn all over. There were maps and charts and that kind of thing, which of course then were completely rebutted when they dropped the number down to 73,000, 33,000 of which is citrus land, which only produces green oranges, which you can't sell anywhere apparently. The point is, with respect to all of this, is that the public purpose is a very, very important part of this case. And apparently from listening to the arguments both of Mr. Rumberger and Mr. Hanna, it's sort of a Carmack approach to things. Whatever happens to be in the mind of the district, which they don't disclose, can be the basis of a project. That's not the case. There are no cases where a project is simply a part of an acquisition, where there is no plan. They don't have a plan. Their plan is to buy the land and figure out what they're going to do with it later.
But I guess my problem with what you're saying, and it's hard not to see who you're here representing a competitor sugar company, and what we're looking at is whether this purchase by South Florida Water Management District is public purpose as far as serving the purpose of the environment and reclaiming and restoring the Everglades. You agree that would be, if it does this, if it contributes to do it, isn't that a public purpose?
No, ma'am. I mean, is it a public purpose generally? Yeah, sure. But is it a public purpose under the statute and the case law? No. Mr. Leighton represents people who live in the Everglades. Okay, so if I am tarred by the fact that my client is a competitor, I would suggest that he is not so tarred, and his folks have been living there for a number of years.
I thought the concern was, though, that they weren't going to be able to do some other projects that were in the works, that there's a much more complex political
Well, that does impact us, of course, Judge, because the fact of the matter is that you have a situation where we are paying taxes, special taxes, as landowners in there, and those monies now are being rediverted to this purpose and are not available for other purposes, including having basically blown $280 million for the reservoir, which they claim, which is canceled, which is money that is now going to have to be respent.
But even if the complaint didn't change, wasn't that the focus, though, of testimony that the judge heard? That is, that it was the project change when it went from $187,000 to $73,000. The judge was aware of that.
But the scope of benefits, Judge, which was attached to the initial petition, never changed. Nothing that Mr. Rumberger said, is contained in the summary of benefits, and very little of what Mr. Hanna said was contained in the summary of benefits. What the court has to keep in mind
But don't we have to look at, I mean, the summary of benefits is all well and good, but don't we have to look at the entire presentation that was made? I mean, the trial judge was given information of what was presented to the district when they decided to go with this kind of project in the first place. And so we aren't really limited to just what is indicated in that few pages that says the summary of benefits.
Well, respectfully, Judge, the circuit judge, sort of like the ancient Japanese princesses that had their feet bound so that they couldn't grow and they had to be carried around for the rest of their lives, the trial judge was very limited in what he was allowed to look at, and he made that clear. Judge Haffel was very disciplined in terms of his approach to what he was doing, and he made it very clear what he wasn't able to consider. And what I think you need to consider is the fact this is a bond issue that has been approved not by the voters, not by anyone who has received one vote from an elector or a voter in the state of Florida. The only people that have any responsiveness to the people of the state of Florida that are reviewing this is this court and Judge Haffel before you, and Judge Haffel felt he was very limited.
So you suggesting there's a different standard when it's the Water Management District than if it was a municipality?
Absolutely, Judge.
And have we ever articulated that?
If you look through the cases, you'll find they're always discussing legislative bodies.
But I'm asking you, have we ever held that the bond validation inquiry for a Water Management District is different from any other public entity?
The issue has never been presented to you that squarely. But I think one of the points you have to keep in mind here is they keep harping in all of their papers about the fact that there are collateral issues, okay? A collateral issue, I think in the plain use of the English language, is when you want to question whether or not $10 million is enough for something or $10.5 million. But when the entire financial underpinning of a transaction is under question, the circuit judge has to be able to look at it. And he was not able to look at it. He wasn't allowed to look at it because of his understanding of what the rulings of this court were. What is happening here, and the court has to be very, very conscious of it, is an attempt to expand the doctrine of Strand. And that is a very important thing for the court to consider, because if you recall, Strand was decided on stare decisis, which I think if it was a zoning case would be an exceptional use or an unusual use. The court said we have a long history of having followed this particular rule. It is not good to be changing rules. That's fine. Why was that? Because the school districts all had a stroke at the thought that they would have to get bond validation voted by the voters every time they wanted to build a school. Well, it's one thing to have a plot of land that you buy, build a building on it, and if they then non-appropriate, as they refer to, breaching the lease agreement, then the bondholders can come in, presumably sell the land and the building and be made whole. Not the case here. We're not talking about a school building and a quarter-acre or 5-acre parcel of land. We're talking about taking $560 million, or whatever the number is, $536 million, buying land that can't really be used for anything else, that may already be encumbered by other uses, and that becomes the security. The South Florida Water Management District carries this obligation on their books as long-term debt, and yet they come in and say, oh, it's just a lease. You are being asked to take the whole concept of COPs, the COPs, the whole concept, which really is a strand issue, and to expand it beyond where it wanted to be. And I'll repeat something both that the Chief Justice and Justice Lewis said in their dissenting opinion in Strand, which I think is very, very material.
Which didn't carry the day.
Pardon me?
Which didn't carry the day.
There's always a chance for another tomorrow, Madam Chief Justice. And we're feeling good about that. We'll only be offending Justice Pariente at this point in time. Justice Lewis said in a dissent that you joined in, like the hapless protagonist in Groundhog Day, this court will be forced to continuously relive this controversy until we get it right, because the constitutional provision at issue simply does not support the gloss placed upon it by Miami Beach, which the majority erroneously expands to this road construction context and related distinguishable decisions.
But what we're talking about in that case, whether or not the interpretation in Miami Beach, which says pledging the ad valorem taxes is different from using the ad valorem taxes, which is basically the language that was actually in the constitutional provision. So I think we're really maybe talking about a different issue here, aren't we?
Well, I don't like to contest the point being raised by the Chief Justice, but my understanding of reading Strand was you all voted 6-0 or 7-0 to toss that, okay? And then when there was an uproar that came from the school boards, the case was re-argued by the court and flipped then to a 4-3 decision or a 6-2 decision on the same point. The fact of the matter is, don't make a mistake about this. They are asking you to give to people who are not elected by the people, who are basically put there by the governor, sort of a seven-fingered hand of the governor, to approve $536 million worth of the taxpayers' funds without their approval. And what you're going to do,
Clark, you're going to have to bring your argument to a close here. You have used more than your time. If you could just sum up for us.
Let's just get down to the basics. There's going to be about $6 or $7 million worth of rent. There's going to be $40 million worth of debt service. You figure, okay? The fact is that what should happen here, at the very least, is Judge Haffel should have hands untied and be allowed to look and see whether or not these issues are collateral or whether they are intrinsic and significant. Thank you for your patience and time.
All right. I thank all of you for your arguments here today. The court will take its morning recess for 10 minutes. The next case on the court's agenda is Dufour versus State. Are the parties ready?
Yes, sir.
You may proceed.
May it please the court, I am Maria Deliberato Chamberlain, and I, along with my co-counsel, Mari Louise Samuels-Parmer, represent Donald Dufour. Also present is Gretchen Swen on behalf of the American Association for Intellectual and Developmental Disability, who filed an amicus brief on Mr. Dufour's behalf. I'll be sharing part of my time with her this morning.
Now, you're going to do 9 minutes. She's going to do 7, and then you'll do 4 for a rebuttal.
That's correct, Your Honor. Mr. Dufour is mentally retarded and has been his entire life. He received D's and F's in first grade, failed second grade. He was placed or socially promoted every year thereafter until he withdrew from school as a 17-year-old 8th grader. Joyce Jones taught Mr. Dufour 7th grade English. She thought he was quite possibly mentally retarded. Nancy and Bill Cutts both stressed that the school that Mr. Dufour went to had no programs for mentally retarded children, and children could easily slip through the cracks. Dr. Keyes confirmed that over his 30-year experience with children with mental retardation, he had never seen a case where children got D's or F's in first grade unless something was developmentally wrong.
In the direct appeal, not that I understand you have another shot when you do your post-conviction, but I always look to see, well, was this a thread throughout the whole case from the beginning? Was there any evidence in the original trial put on about his mental retardation, which say is so clear that it's clear and convincing that he was mentally retarded?
The only evidence put forth at the trial, which was Dr. Gutman's testimony, who testified that Mr. Dufour was of average intelligence.
So
at the post-conviction hearing, Dr. Gutman testified that his basis, his statement, reason that he said he was of average intelligence, was based on the 10-question mini-mental status exam,
but
that it was the leakiest parameter of his exam.
Is it not significant in looking at this issue that we have to look at the totality of what happened? Because what the Supreme Court has mandated for us is that we don't want to execute individuals who are mentally retarded. And what this court struggles with are those that are come lately claims, and I'm concerned here that it really was not something that his lawyers wasn't something apparent to his lawyers. It wasn't something that really came along until after Atkins came along.
That's actually not entirely correct, Your Honor. What occurred was his lawyers did not present adequate mental health evidence, which is one of the claims in his initial 3.851 appeal.
But they didn't say even then that they didn't present adequate evidence because he was mentally retarded. They really were focused on issues of his long-term drug use and brain damage from drug abuse, correct?
That's correct. During the pendency of the post-conviction hearing, which was in 2002, there was testing by Dr. Marin, the state expert, who found Mr. Dufour to be borderline mentally retarded. It was at that point that Atkins came out. The timing was somewhat similar. Florida had no statute promulgated for...
At that time, in 2002, would not place him below the standard that this court has established in Cherry. We can argue whether that's correct, but isn't that the status?
The score that Dr. Marin initially held was a 74, which would be above the Cherry cutoff. However, two points. Obviously, the Cherry cutoff, which we're arguing in my amicus, will address, but more importantly, the trial court has rejected Dr. Marin's score as not credible.
He didn't reject his score. He gave it little weight. He didn't like the way he testified, and he didn't like his attitude. But even the defense experts testified with regard to the scoring. That was the point. What kind of scoring was done? Well, you're shaking your head. Excuse me, I think that it is, and I've read the transcript, and I've read the order. And Judge Kirkwood gave it very little weight. I mean, you could see clearly that, but even with the scoring, the testimony, even from your experts, would reduce it not below the 70. Now, we can argue whether whether the 70 is correct, but isn't that the fact of the record?
The fact of the record is that the lower court rejected the scoring and gave it little weight because of the gross scoring and administration errors. It wasn't just the fact of Dr. Marin's testimony.
What's the evidence with regard to the scoring?
Evidence is that as low as a 70 is what Dr. McLaren testified, that the score was as low as a 70. The experts said that it was anywhere between a 72 and a 74 when you take into account the gross scoring and administration errors. Our position is that the 74 is consistent with mental retardation.
Well, that's a different issue, and we need to talk the facts. And again, we're not here to act as trial judges, correct?
Correct.
We have to determine whether there's evidence, according to the standards, that support the trial judge's determination, correct?
That's correct. In my position, that there isn't, because not only did the court, he did give little weight to the score, but what the court did it's against established science and this court's ruling in Cherry is he added 5 points to Dr. McLean's 67 to push it above the 70 cutoff.
Let's assume that's incorrect.
So therefore, then, Mr. Dufour has presented competent substantial evidence that his score, a 67, is the most valid score, because that's what the court...
Why is that? I mean, why is the 2002 score not evidence to the contrary?
Because the court, for several reasons. First, the court gave it little weight because of the gross scoring and administration errors. Second, the court appeared to have accepted Dr. McLean's score of a 67 when it took that was the middle score, and then it added 5 points to push it above the Cherry cutoff. So the state, we have presented competent substantial evidence that Mr. Dufour has a qualifying score. He took 3 accepted tests. All 3 of them were within the range of mental retardation.
Incorrect method to reach the amount. He did accept the 67, he did accept the 72, and then he put them together.
It appeared from the trial court's ruling that he accepted McLean's 67 as the most reliable score. Because he added 5 points to the 67 to push it above the Cherry cutoff, which is not in accordance with Cherry, because what Cherry says is there is no standard of error measure, and you can't add 5 points to the score or subtract 5 points to the score.
How about the adaptive functioning?
Mr. Dufour has shown that he meets sufficient adaptive deficits. The court wholly failed to address the adaptive functioning that was done, the objective testing that was done by Dr. Keyes. Dr. Keyes looked at informants across all areas of the state, all areas across Mr. Dufour's life, and spoke to individuals who knew him both prior to the age of 18 and currently in prison. Mr. Dufour has demonstrated that he has adaptive deficits in the areas that are required by Atkins by clear and convincing evidence. He's never had a checking account. He's never lived on his own. He's never been responsible for paying bills. He's always had assistance in obtaining jobs through friends or family. His jobs were sporadic and menial. Those are all the kinds of things that this court has looked at when determining adaptive functioning. In Burns and Rogers, which were 2 cases by this court that the court found the adaptive functioning was too high, both of those cases, the defendants had jobs, had provided financial support for their families.
As Justice Lewis said, we've got a trial judge that listened to all of this and came to the conclusion that he had experienced mental, physical, and sexual abuse as a boy, was a heavy drug user, that he had performed poorly, but then he said that he had participated in teaching a small engine repair class while in prison and talked about other aspects of his adaptive functioning, so that the trial court found that there were no he did not meet the test of deficits in adaptive functioning. Am I incorrect about that?
The trial court did make that finding. However, our position is it's not supported by competent substantial evidence, because if you look at the trial court's findings about Mr. Dufour, the fact that he participated in this small engine repair course, and some of the other findings he made, those things are actually consistent with what people with mental retardation can do.
Passing a GE?
Absolutely. Dr. Marin testified that someone with mental retardation can be taught job skills, can be certainly taught...
Can pass a GED?
I don't know that there was specific testimony about passing a GAD. However, there was testimony that Mr. Dufour cheated on his GED.
Could I please?
I'm sorry, Your Honor.
It would help you a great deal if you permit a justice, you're doing it all morning, permit a justice to ask the questions, and it's more professional to do it that way. Is there any evidence in the record from any of the experts that addressed the GED? I know there was some with regard to cheating or someone helped them, but is there any from the experts?
From the experts, there's no testimony from the experts that would preclude a finding of mental retardation just based on the fact that Mr. Dufour obtained a GED.
That addressed the GED, how it would apply.
I don't believe so.
Okay, I didn't find it. That's why I was wondering if there was something you were looking for.
No, it's certainly, though, the experts wouldn't have relied on just the fact that he passed a GED to either preclude or find a finding of mental retardation.
You are into your rebuttal time if you want to say the rest of
Okay, I'll allow my amicus to have her.
Madam Chief Justice, may it please the Court. My name is Gretchen Swen, and I represent the American Association of Intellectual and Developmental Disabilities, formerly known as the American Association on Mental Retardation, an amicus that has filed a brief in this matter. The AAIDD comes as a friend of this Court to promote an understanding of Florida law that comports with generally accepted scientific principles. In fact, Florida's statute, Section 921.127.1, is not at issue. It is not constitutionally suspect. The statute, as written, is perfectly acceptable to the scientific community. What happened is that the interpretation of that statute that was adopted 3 years ago in the Cherry case put Florida off step, out of sync with this normative science that underpinned Florida's statute, as well as the United States Supreme Court decision in Atkins versus Virginia. It's interesting to note that Florida was actually ahead of the game in this issue. It wasn't that the U.S. Supreme Court came down on high and dictated to Florida to get in line with evolving standards of decency that had banned the execution of the mentally retarded. Florida got there before the U.S. Supreme Court made that pronouncement. The problem is the plain language of that statute, this Court has correctly assumed give the answer you need in order to apply it to capital cases. However, the Court read into that plain language a hard cutoff of a 70 IQ that is not in the statute and does not comport with the science of assessing IQ. So if we'll look at the statute, what Florida has directed courts to do is to identify those persons who are eligible for capital sentences, who have significantly sub-average general intellectual functioning as measured by a performance that is 2 or more standard deviations from a mean score on a statutorily acceptable test. Now, that language, which seems very plain on its face, in fact, is a scientific term of art. What does it mean to be 2 or more standard deviations below the mean? I submit that words such as bug, chip, crack, driver seem to be words that are plainly understood. But if we put those words into the context of computer programming, it's suddenly clear that those words aren't the plain language that we thought they were on first impression. Similarly, with this notion of 2 or more standard deviations from the mean. In the realm of IQ testing, a mean is a perfect concept, a pure concept. You have a valid test that produces, in most terms, 100 as an average IQ score in the perfect world. And yet, scientists understand that intelligence is an exceedingly complex phenomenon, something that will never be ascertainable in a perfect way. Ergo, in taking a valid test and having a qualified, trained professional administer that test under the best possible circumstances, you're going to get a specific score that science understands is not the be-all and end-all of a person's IQ. Therefore, that number that is produced in a specific context has to be interpreted in terms of the standard error of measurement. This is a construct universally accepted in the mental health profession and is explained at great length in manuals produced by my client, the most recent of which came out this year. But this concept of the SIM, the standard error of measurement, when applied to a specific score, means you add both plus and minus generally 5 points. So if someone scored a 72 on a specific test, validly administered, you would still, as a good scientist, add 5 points and subtract 5 points.
So if somebody scored a 70, could the trial judge then say, I think that it was more likely a 75?
Well, what the experts informing the trial judge should do, if they are validly trained and listen to the authoritative science, should know that that individual score taken on a specific date needs to be understood and translated into a range of confidence. And that would, a 70 would then become 65 to 75. And in that range is where the true IQ score actually exists. That's how science understands.
What would a trial judge then do with that? Would a trial judge be correct in saying, because this range is from 75 to 65, then he's not retarded?
No, Your Honor, because in fact, as even the U.S. Supreme Court recognized in Atkins, the upper range of mental retardation goes up to 75, 70 to 75, and below is where you have intellectual dysfunctioning. And the reason why you have to understand that upper range as being permeable is that the vast majority of people with MR exist in that range, that upper range. 80 to 90% of persons with mental retardation are going to be 65 to 75 IQ.
So I mean, the bottom line is that you're suggesting that when this court adopted a number in Cherry, correct, that number should have been 75, not 70.
Not precisely, Your Honor.
Well, tell me precisely then.
Your Honor, I know I'm very aware that the court, all courts, are attracted to bright line rules. They're very helpful to courts below.
So now you're going to say that somebody up to 78.
Not exactly, Your Honor. But what I would say, that what the science says, it has nothing to do with this particular case.
Well,
but the nature.
I'm asking, what's wrong with Cherry? I'm trying to understand, and if you can just say it in words that we as judges can understand, it would be most helpful.
Certainly, Your Honor. What the science directs is that any time you have a hard cutoff, and you're trying to make that be a variable that you can say, if you hit this number above or below, you qualify as mentally retarded, that is bad science. Instead, what one can do, quite accurately and comport with science, is to say, if an IQ score, when the SIM is taken into account, produces a range that includes the number 70,
right,
then you probably have passed the first prong.
Okay. Well, I mean, from that prong, then 75. If you're above that, you add 5 points. You'll never get below 70, according to the schools I went to. Now, granted, they were not as good as yours, probably, but I can add up to 5. And so you're saying that according to the way we're looking at it, if we would say it's 75, not 70, is that erroneous?
Your Honor, the difficulty from the AAIDD's perspective is trying to settle on a bright line arbitrary cutoff.
Well, that accommodates, does it not, the range?
Yes.
Do you agree that at some point there's got to be some number that if you're above it, that you're not considered scientifically to be retarded?
The problem is, Your Honor, looking for any kind of digital response to a non-digital phenomenon.
Then we might as well do away with everything, because we get a number for anything that means anything.
No, Your Honor, some things.
This is circular. I'm sorry. I'm trying to understand what you're saying. But we keep going back. If there's a 5-point margin of error, one way or the other, then I'm having difficulty understanding how if somebody scores 80, that you can get below 70 with that margin of error.
You cannot, Your Honor.
All right. So then how about 78? I still find it hard how you can get below 70 with that margin of error.
Your Honor, you are correct. However, what is incorrect is this fixation on the number 70. What one can do is say the mean is this perfect 100. But the score is never perfect. It is a range.
What number would you suggest that we should settle on, if not 70?
Your Honor, the simple solution is to say that any IQ score produced from a validly administered test by a qualified professional needs to be interpreted in the context of the sim and then turned into a range. If that range includes the number 70, then it's more probable than not that you pass the first prong. But then I would direct Your Honor to the fact there are two more prongs to the test.
You mean in the statute, the adaptive functioning and the others?
Yes,
well, that's
and
fine. We understand that. The cherry discussion is not about all those
right.
others. So I'm still finding it hard to understand, with all that you said, there's a lot of talk you talked to me, that you're saying it must be that the 75 would preclude it from falling into your range because you can never get below 70 with a 75 score if you apply that margin of error.
Your Honor, it's because the way clinically trained professionals who administer IQ tests work is they don't say, I pass the first prong, check, then I go to adaptive deficits. If the score is at the upper limit for mental retardation in the context we were just discussing, you would still need to look at adaptive deficits. Even if the score were 65, a qualified technician knows I have to look at those adaptive deficits and I have to find significant impairment in at least one of three distinct domains.
Well, I thought that there were others that said you had to have two.
Well, part of the confusion, Your Honor, is that since Atkins was announced, the definitions have changed in terms of organization, but not in terms of underlying substance. The AAIDD...
Well, haven't the parties here asserted that you have to show deficits in two of certain adaptive functions?
What the parties have asserted is that out of this whole range of variables, you have to show deficits in at least two areas.
Right, and you just said you have to show it in one.
What my client has said is that there are three categories of domains: conceptual, social, practical. And someone can be mentally retarded who has significant deficits in one. And that can even be the case if their IQ is slightly above 75, if they're extreme enough. The analog for this is, it's an offensive concept, particularly to my client, but the idiot savant. We're all familiar with that fact that the human brain is a bizarre phenomenon, and someone can be exceedingly gifted in one area and then painfully limited and dysfunctional in another. And so the adaptive deficit, which can be tested objectively, also looks at that. But, Your Honor, the problem is saying, and this
excuse me, you have well exceeded your time. If you would bring this to a conclusion.
Thank you, Your Honor. The important thing from the scientific perspective, and why I'm harping on that, is because the Supreme Court directed courts to look to the science. It's rather unique in that, and that a legal principle was announced in the context of contemporary science. And so we urge this court to reconsider its Cherry decision and the way it interprets Florida law so that it is in line with contemporary scientific consensus. Thank you.
Thank you very much.
Good morning. Scott Brown on behalf of the state of Florida. Justice Lewis, all four experts agreed below that Donald Dufour had a qualifying waist score in 2002 above the cutoff this court set in Cherry.
Do you agree that the trial judge was incorrect in the manner in which, even if you accept our current law, in the manner in which he approached this IQ score, though?
Well, I think he was trying to reconcile the scores, but ultimately what he concluded was you don't add 5 points. He was looking at the scatter, and he ultimately concluded that he was above the cutoff. So he ultimately concluded that Dr. Marin's test...
Didn't he add the 5 points to the 67 to get it up to that point?
I don't know what his calculus was, but I know his bottom line conclusion is he didn't meet the 70 cutoff. So we know that's his bottom line conclusion. He didn't like Dr. Marin's cavalier responses, some of them. He certainly didn't like being questioned after administering 10,000 intelligence tests. But even if you assume, you look at the defense experts, they rescored this test. They gave Donald Dufour the benefit of every rescoring, every possible computational error. Dr. Marin's score at worst dropped 1 point to a 73.
In Dr. Marin's evaluation 2002,
correct.
He was a state expert?
Correct, Your Honor.
Was there a IQ testing by the defense in 2002 in connection with the evidentiary hearing?
No, Your Honor, and actually, the interesting point about that, I know you raised that on my opponent when she was talking. CCRC represented Donald Dufour for that 2002 hearing. They hired mental health experts who critiqued Dr. Gutman's analysis or exam from the trial. None of them opined, including defense stalwarts like Dr. Berlin, that Donald Dufour was mentally retarded.
And none of them actually even commented on deficits in adaptive behavior as a result of mental limitations.
No, Your Honor. And it's clear that Donald Dufour, even Dr. Berlin admitted during the evidentiary hearing that Donald Dufour was seen as a leader among members of his social group.
Well,
these were coldly planned.
So that you've got, I mean, to me that's somewhat significant as to the evolution of these claims. So Marin was offered, Dr. Marin was offered
Correct.
in 2002, his IQ score, the 74, with the verbal IQ of 85. I know one of your colleagues always likes to say you can't fake smart. Has anyone attacked that, the verbal IQ of 84?
You know, I don't believe so. And again, even if you go back, and there was a lot of testimony about how you administer the test and the reverse order rule. But the bottom line is Dr. Marin did a thorough examination, and the interesting thing here, Your Honor, is on rebuttal and surrebuttal, Dr. Keyes, the defense expert, admitted that, well, there were some scoring errors that Dr. Marin made, a minor, that inured to the state's benefit. In other words, they increased his IQ. So ultimately, Dr. Keyes, his last testimony on IQ, and this is after he'd already testified on direct, was that Donald Dufour had a 74 on Dr. Marin's test. The same exact score that Dr. Marin and Dr. McLaren, Ms. Chamberlain said that Dr. McLaren came up with a 70. No, he didn't. The testimony below is no matter how you look at Dr. Marin's test, and we have it on videotape, you can't get below a 70. You couldn't get it below a 72 or a 73.
But let me ask you about that, just the pure IQ issue. I know you're not going to say we got it wrong in Cherry, and I have to look back at Cherry. I think it was a unanimous decision. But is Florida now, in our interpretation of the way that the real world of IQ are we at a step with the majority of states? In other words, somebody who has a 71, is it just as likely that they're in the mentally retarded range because of the standard era of measurement? I mean, that concerns me as to how we got there. So
no, Your Honor. In fact, this court in Cherry did a survey and cited a case out of Kentucky, and this is, I believe, 2005, Commonwealth of Kentucky, and it's cited in Cherry. And 17 of the 24 jurisdictions have a similar bright line cutoff. In other words, it's 2 standard deviations below the mean on a qualifying IQ test or an actual 70 IQ. So this court, to its knowledge, and no authority to the contrary has been cited, is not out of step. And, you have to put...
So your contention is we were actually interpreting the plain language of the statute, not making a decision as to whether whether there's some room in the scientific community to employ the standard era of measurement.
This court, it is a bright line test, and this court has repeatedly upheld that.
I guess the area where I'd be concerned is the one where somebody's got a 71, but you see clear evidence throughout the history that this person has not functioned as we would expect someone to function in the world. And I know there's always, what did the U.S. Supreme Court, what were they getting at as to why we wouldn't want to execute mentally retarded? And despite whatever gloss we put on it, we're assuming there's a class of people that are so limited in their ability to function in society that it would be inhumane to execute them.
Correct, Your Honor.
And so the concern would come if it really looked like they had 2 of the other prongs, and there was a question as to where their IQ had been scored. But I'd like you to maybe address that. We don't, as far as the adaptive functioning, that we don't, do we have that or do we not have that in this case?
No, we clearly don't, even under the preponderance of the evidence standard. And first of all, this court has recognized that a cold, calculated, and premeditated murder on its own terms is inconsistent with the conduct of a mentally retarded individual described by the Supreme Court. They're unlikely to plan, premeditate their crimes. What we know about Donald Dufour and his 5 murders, they're all planned. He eliminates witnesses. He said during trial to an associate, anyone who sees my face or hears my voice has to die. He isolates his victims. He plans it out ahead of time. And there's abundant evidence in the record of criminal adaptive behavior. Not only is he considered, the leader of his criminal group, planning and organizing crimes, Dr. Lippman's notes from the 2002 hearing are illustrative. I mean, he describes dropping a car off, robbing an individual and dropping a car off in another section of town to throw the police off. This is an individual who has been described by family members as someone who is very persuasive, his older brother. He's persuasive, he's a leader, he can talk you either into or out of anything. And this is a clear, consistent personality characteristic of Donald Dufour. He's manipulative, he's persuasive, and sure, he hasn't had many jobs, but he doesn't like the wages he can earn. And in fact, he explained to Dr. Lippman why he had a job at Orlando Armature. And he said, I couldn't earn the kind of wages that would allow me to have the lifestyle I wanted to live. And Dr. Marin said, look, he's worked with mentally retarded at the McDonald Center. Most of the time, they're happy to have a job and be productive. But Donald Dufour, he chose the criminal lifestyle. So I don't think this court should put any stock in the fact that Donald Dufour didn't really hold a job. He didn't want to. He could live a parasitic lifestyle.
But don't we have to be careful as far as determining someone's not mentally retarded based on the nature of the crime? Don't we have to look at the other surrounding aspects? I mean, did he live on his own?
In fact, most often he did not. But there's clear evidence that he is capable of it, because after he committed the 2 Mississippi murders, his associate was caught right away. Donald Dufour obtained a room in a boarding house under a false identity. He cut his hair. He dyed his hair. So he can actually live on his own if he is forced to. But he's had people help him along the way. He lived with Stacy Siegler, who testified that he was concerned about his appearance. He profited from her prostitution. But no one in their social group thought he was in any way intellectually limited. And that's what the trial court focused on. There's absolutely no evidence below of poor adaptive functioning. Dr. Keyes administered a SIB-R to 2 death row inmates, Cormandy and another individual who were in a cell next to him for about a year. So that's how they arrived. And one family friend from 25 years ago, the mother of a family friend, that's how they came up with adaptive functioning deficits. They ignored the lengthy history of records in this case that show Donald Dufour cares for and is concerned about his health. All the DOC records, his letters, all of which are completely inconsistent with the notion.
Do we have letters in this file written by him?
Yes, we do, Your Honor, to Stacy Siegler. And again, there are some grammatical errors, certainly, but they are, even according to the defense expert, Dr. McClain, he fought forfeiture of his car from prison in Mississippi. These are all examples of adaptive behavior over a number of years that the defense had no counter to below. So the trial court there's absolutely no evidence on this record that he would meet the adaptive function.
What about, did he obtain is there any doubt that he obtained his GED?
No, Your Honor.
And what about the teaching or helping to teach the small engine repair class?
Again, another example in the DOC records. He not only assisted and completed the course, he was assisting the teacher in actually teaching to other inmates. That little assessment group, it was 3 individuals, thought that he was definitely capable of college work. Again, another indication in the record among many that he functions well above those. He's considered competent.
Where did he go to? He had dropped out of school at what age?
I believe he was in high school at 17, 16.
Because I had thought that there really was an issue here that probably whatever drove him, it was primarily due to this childhood that was, at least in the more recent evidence, that victim of sexual, physical, mental abuse, drug use, repeated drug use, that any deficits were coming from that behavior.
And also, Donald Dufour wasn't terribly concerned with school because he explained to Dr. Lippman, again an expert from the 2002 hearing, and we have his notes in the record, he explained that he did nothing at Wymore Tech but sell drugs and get high. So again, lack of academic success is not surprising under those circumstances. But again, the defense makes much of those school records, but what they ignore is he was actually administered an IQ test, the Lorge Thorndike, and scored an 80. With what we know about Donald Dufour, that's probably a pretty good estimate. Again, it's not an ideal test. It's a group test, but it should be taken into account along with his school records. And again, he could...
Speaking of IQ tests, it always troubles me when we have IQ tests in our record, and here we have a couple of them which clearly fall below the 70 mark, assuming we're going to stay with the 70 mark. We have the 67 and we have a 62. But we pick out the one that says that 73 or 74 IQ and say, well, he has that, so we're going to say he's not mentally retarded. What do you do with these other IQ tests? How do we factor those into our determination about whether he is or is not mentally retarded? I mean, you would agree that those other two tests would at least get him
in the range
into the first prong of the intellectual functioning.
Sure.
Correct?
But the interesting thing about IQ tests is, I hate to say it, but you can't fake smarter than you are. You can always malinger or have a bad day. But what we have here is clear evidence that those two lower scores were the result of less than optimum effort, or in fact malingering, as the state suggests, because Dr. McLean came in to test him for mental retardation and told him what she's there to test him for. After Donald Dufour had just signed a motion not too long ago saying, I'm retarded, you can't execute me. So she told him up front, and Dr. McLaren had some concerns about it. You're going to tell him up front what you're testing him for. But more than that, Dr. McLean administered two tests, pointed tests, to determine whether or not he was malingering, the TOM and the MFAST. And guess what? Both of those tests revealed that Donald Dufour was well into the malingering range. Now, Dr. McLean recognized that, two tests showing malingering, but my IQ score is good. It's pretty inconsistent. She tried to explain that, well, the TOM's not, that test of malingering is not normed for the mentally retarded. The problem with that theory is Dr. Keyes didn't administer an IQ test, but what test did he administer? The TOM. And Donald Dufour did perfectly fine on that test. So we know that TOM administered by Dr. McLean and Dr. McLaren before testing was a result of malingering, not any lack of ability. The MFAST also is a test that measures malingering. It came out clearly in the range of malingering. So again...
Did the trial judge say that he had been malingering when these two 2005 tests were administered?
Well, in fact, he did discount Dr. McLean's testimony because she discounted her own tests that showed he was malingering. So yeah, when he ultimately came to the conclusion that he did, he discounted her scores because she discounted her own test
of malingering. Dr. McLaren came up with a full scale of 62?
Correct.
What was his explanation for that low IQ?
Lack of motivation, malingering.
I mean, he actually, he testified that it was an invalid score?
Yes.
You have, Dr. Zimmerman was 1989.
Correct.
Was he a defense expert?
That is my understanding.
And so that had that
a
IQ
Slauson.
was a Slauson, which is not one of the recognized tests, but is there an explanation for the 66 IQ?
I thought it was even lower than that. He came up. It's a test of performance, and it's a quick assessment instrument, much like the beta. Donald Dufour was on death row at that time, and that was the first indication that anyone had that he might be mentally retarded.
But then that wasn't used in the evidentiary hearing?
No, not in the 2002 hearing. None of the experts, again, this CCRC had this evidentiary hearing where they're complaining about Dr. Gutman being ineffective and not finding brain damage or some other malady, but they didn't contend that he was mentally retarded. They wait until long after Atkins comes out. I suggest that this is a Johnny-come-lately claim. It's not supported by the record, that Donald Dufour does not meet either the intellectual functioning prong nor the adaptive functioning prong of mental retardation.
Mr. Brown, did you do the trial on this?
No, Your Honor. I did attend the evidentiary hearing.
I'm concerned about the way that this judicial notice, what comes evidence. This is a hearing that should follow the rules of evidence. You
Correct.
Agree with that?
Yes, Your Honor.
And I understand, because I've been there, been in those shoes where the rule of evidence was changed to allow experts to rely on things that experts generally rely on, even though that may not be in evidence. But I see here a real problem with the manner in which the state was attempting or did place into evidence several of the items that otherwise would not have been in evidence. They were not properly authenticated at times. Would you address that last point? Because this can't be a free-for-all as we go into these kinds of hearings.
First of all, the trial court indicated that while the documents were admitted, they did not form the basis of his opinion and were not considered.
Well, that's just saying that it was erroneous, but I didn't follow through with the error. I'm trying to, these things, if we're going to have orderly proceedings and be governed by the appropriate rules, we need to make sure that they're followed. And not to have a judge at the end let everything in, although it's erroneous as can be, and say, I didn't really look at it.
None of that evidence was shown to be erroneous. Donald Dufour had the ability to challenge any particular document.
It wasn't placed into evidence in a proper manner, was it?
I believe it was, to support the expert's opinions. These documents
No, that doesn't come in to support an expert's opinion.
That's how they were offered, Your Honor. It's my recollection.
But that doesn't get them into evidence.
As, maybe we're talking because it's a bench trial of formality. We admitted them as an exhibit, and the defense did as well, a number of documents, the same going back years, and so during the hearing. But the important thing is the experts themselves, even the defense expert, Dr. McClain, admitted that these letters were the kinds of things that she had already reviewed, the DOC documents, and she considered them as part of her opinion. So I don't think there's a need here to reverse and remand, especially when the trial court in this case indicated that those documents themselves did not form the basis of his opinion.
Again, you're avoiding my question. Are we going to let just anything go to these kinds of hearings without following the rules of evidence? I agree that they can be cross-examined, but does that mean just because they can be cross-examined that a document comes into evidence? I know of no rule that says that.
Your Honor, I submit that if you look at the documents themselves, if we're talking about which rules were violated, there was a rule violated, Florida Rule of Criminal Procedure 3.203, where the state had no notice, and in the reply brief, they said that we had noticed that this expert on mental retardation had examined Donald Dufour. We did not prior to the hearing. And at that late date, it was too late to depose this expert. But there's a clear violation of a rule of criminal procedure in this case, and it's not on behalf of the state. There's an expert who tested Donald Dufour.
I can see I'm not going to get a direct answer on this one, so.
I don't believe that if you look at the purpose that they were admitted as an exhibit and they were not relied upon by the trial court, I do not believe that violated the rules of evidence. That's my answer, Your Honor. Thank you.
Justice Periente, I would just like to go into the procedural history of this case. I think it would help clear up the confusion. There was a notice of evidence intent to rely on Atkins that was filed by CCRC in November of 2002 in the middle of the evidentiary hearing. It became clear that at that point, Mr. Dufour was going to rely on Atkins to show that he was mentally retarded. What sort of procedurally happened was when the 3.851 came up for appeal, CCRC filed a notice in this court to relinquish jurisdiction to go back and do the hearing so that the court would have one complete record, both on the mental retardation and on the 3.851. This court declined to grant the relinquishment of jurisdiction.
I understand that, but if you had experts that were preparing, and it's not like mental retardation is a new concept. It's a new concept to ban or make someone ineligible, but it always was considered mitigation. So it seems that the fact that none of the experts even talked about the issue of mental retardation, to me, is significant.
But I think that they did, because Dr. Marin is the one that testified that he was borderline mentally retarded. The position of CCRC at the time, before Atkins came out, was that while, yes, mental retardation could be mitigation, it wasn't a bar to execution, and they felt the stronger evidence was the evidence of brain damage. Are
you telling me that if you've got in a case mental retardation and brain damage, you need to pick and choose?
Certainly not, but Dr. Berlin, I think it's important to note that Dr. Berlin did not test for mental retardation. There wasn't, the only person who had done the waste in 2002 was Dr. Marin. As soon as CCRC learned of Dr. Marin's waste,
if mental retardation is so esoteric that it can go through 20 years where someone's representing this person and no one says, you know, this guy's got some significant deficits. I mean, obviously he's competent, but are we saying that mental retardation is so subtle that you could go through that many years and not realize that there are significant deficits in a person's intellectual functioning?
Well, I think
that's what my concern is.
And I understand that. I think actually that's what's important about Dr. And I'm going to blank on his name, the Slauson that was given in 1989, that Dr. Zimmerman found that Mr. Dufour was in fact mentally retarded. So I don't think, and while the Slauson is not an accepted test, it was a individually administered test by a neuropsychologist as given part of a full neuropsychological battery. So I don't think that all of a sudden...
Was that offered into evidence in the evidentiary hearing?
In the evidentiary hearing in the mental retardation case, Dr. McLean actually spoke to Dr. Zimmerman and relied on his findings as a piece of her opinion to show that, while everyone agreed that this Slauson wasn't an accepted test, it certainly was predictive, I think, was her testimony of Mr. Dufour's, of his actual functioning. I would like to touch on a few other points that Mr. Brown raised, specifically about Mr. Dufour. He did withdraw from school in the 8th grade at age 17, and there was testimony about his disinterest and lack of interest in school, but what's unclear is that he got D's and F's in 1st grade. I mean, he was 7 years old. He certainly...
explanation for that as far as learning disabilities and those kinds of things? Was that suggested by any of the experts?
It was not. The testimony about the elementary school, we presented witnesses, teachers who had testified at the elementary school and middle school for over 30 years, that there were no such programs.
Expert that commented upon those early failures. That's your statement?
No, Dr. Keyes, all the experts, Dr. Keyes and Dr. McLean, testified that those grades, the D's and F's in 1st grade, were predictive of, were certainly an indicator of something being developmentally wrong. Not a learning disability, but
something wrong.
But a demonstration of low IQ was their testimony, was that the school records, Dr. Keyes and Dr. McLean relied on the school records extensively as far as the onset before age 18, show that Mr. Dufour had these difficulties all his life.
How about the testimony of a sister who had lived with him and said that he didn't have any problems, no problems with life skills. He had a brother who was, at the time, diagnosed with mental retardation, correct?
That's correct, he did.
And they drew a distinction between the two.
They did, and one of the distinctions that was drawn was that John, the brother who was diagnosed as retarded, although he never really had a formal diagnosis either, was violent and had outbursts in class, and that's why he was transferred.
Went to a school for the
correct.
Did not deal with those who were nonviolent.
Correct, and the testimony.
We've come a long way in that area.
Absolutely, and that testimony was presented below. Just briefly, with respect to the stepsister that testified, her credibility, her testimony was given little weight by the court because she was directly contradicted by the expert that Mr. Dufour, or the witness that Mr. Dufour presented, that showed that the stepsister really was completely testifying essentially untruthfully about the relationship that this woman had with Mr. Dufour. Her testimony was found not credible by the trial court. The defense has put on significant evidence of adaptive deficits. One of the things that the court, Mr. Brown discussed the crime, and I think Justice Pariente was concerned with the sort of per se finding of just because there's a cold, calculated, premeditated, that precludes a finding of mental retardation. And I think that the science is against that. And also what's important to focus on with adaptive deficits is you need to focus on what the person can't do, not what they can do. It's the weaknesses, not the strengths.
And with that, you have exceeded your time also.
Thank you, Your Honor.
Thank you.
I would ask this court to vacate the sentence.
Here today. The last case on the court's agenda for today is State v. Stang.
May it please the court, counsel, my name is Sarah Max, and I represent the state of Florida in this matter. In Baker, this court stated that it had repeatedly revisited the parameters of post-conviction rules to balance the needs of the court system against the rights to habeas relief. With limited exceptions, defendants must file post-conviction motions for collateral challenges to their judgment and sentences.
You agree if a sentence is illegal, it can be attacked at any time?
Through a post-conviction motion, yes, Your Honor.
So what is habeas? Does habeas have any relevance to individuals serving sentences?
Habeas is proper for issues attacking Department of Correction functions, not for issues attacking sentencing court functions.
How about if something is entered, like in this case, there I am, fat, dumb, and happy, sitting in a jail cell someplace, and unknown to me and unknown to my lawyer or anyone, the DOC's communicating with the court, and the court's entering judgments that extend the time I'm going to have to be sitting, and I don't even know it.
It can be properly filed as a post-conviction motion. Yeah.
You've got that sentence correct.
Yes. So, yeah.
That sentence down. I understand that sentence.
There is an avenue of relief available, yes, as a post-conviction motion. It's not that no avenue of relief is available.
So what case is this in conflict with?
This is in conflict with Baker, Your Honor. What the court did in this, the Second District did in this case, is it cited to TO, Electoral Regional, and it cited to Murray. These are two pretrial habeas cases for their authority to handle this as a habeas case. That was inappropriate, a misapplication of this court's precedent, and ignored the Baker case. This is not a pretrial case. Pretrial does not have a set of rules that must be used as in the post-trial context. Pretrial relies exclusively on habeas, and to cite to a pretrial habeas case is a misapplication of this court's prior precedent.
So we would have to, so you're claiming conflict based on misapplication of Baker?
Misapplication of both T.O., Murray, and then ignoring Baker. Yes, correct, Your Honor. That is correct. This court went even farther and ignored the collateral estoppel principles in McBride and also ignored the credit for time served law in Mancino, but the primary issue, the primary misapplication is in the Baker T.O.
Well, I thought in McBride we recognized that if there was a manifest injustice, that was an exception to the prior adjudication on the same issue.
The manifest injustice, I'm glad you brought that up. The manifest injustice issue is a proper issue and can be raised as a secondary post-conviction issue. It does not give a defendant then an ability to raise a habeas petition.
So you're saying if the Second District had redesignated this as a 3.800A, and then they would have had to transfer it to the 4th District, that the 4th District could have granted this relief if they determined the same thing that the second district determined.
Correct, Your Honor.
So it's a procedural, it's more so you're really claiming a procedural error.
Correct. It's whether or not the court had authority to grant relief. That's really the issue. Second district did not have authority to grant relief. Only the sentencing court had authority to grant relief, or who had appellate court jurisdiction over the sentencing court, in that case the fourth district. You brought up the manifest injustice. The manifest injustice doesn't then give a defendant the ability to file a habeas petition when they're attacking the sentence. What it would do, the issue of manifest injustice would then give a defendant the ability to file maybe a successive 3800.
Let's get just on what Justice Lewis brought up, the underlying facts. I've never seen a situation where the department, and maybe they do it all the time, where a sentence is entered, somebody is represented by counsel, the case is going on appeal, and they write to the trial judge, and a new sentence is entered to the defendant's detriment after the time that the jurisdiction of the court has expired.
Okay.
Do we have that is that a regular process of the Department of Corrections?
Yes, and let me kind of answer the question in two ways. One, this memo from the Department of Corrections was entered to clarify the order, the sentencing order, because it was internally inconsistent, and they didn't understand what that order, they didn't understand.
Why wouldn't an individual affected by that be entitled to know what was happening?
I agree with you. The parties were entitled to know what was happening.
They weren't, were they?
No, they were not.
And you said this happens on a regular basis. I mean, I am absolutely sitting here as an officer of this system saying, my goodness, what's going on?
Now, the Department of Corrections has changed the way they do this. Their internal operating procedure is to now notify the parties when they send out these letters. Absolutely. But when they are enforcing these sentences, administering these sentences, that's a better word, they will get these orders that they don't understand. And so they communicate with the trial court saying, okay, we don't understand this order, we need some clarification. When it's on appeal, as in this case, the court did not have jurisdiction to enter an amended order. So the issue then becomes, well, what's appropriate? In this case, they entered an amended order when they didn't have jurisdiction. Okay, well, that's not valid. You can't do that.
But that's okay, and I appreciate that candor. That's a pretty significant issue that a court has entered an amended sentence to the detriment of the defendant when it had no jurisdiction to do so. Doesn't that render that amended sentence void and illegal?
Absolutely, yes, Your Honor. The order, the sentence itself, remember, comes from the sentencing transcript. So the sentence itself is not void or illegal. And the sentencing transcript, which was attached to the amicus brief, clearly states 27 years with 1,915 days of credit.
Was that before the second district?
It was not. When the second district asked the state to respond, it was a petition for writ of cert from Hardy County. The only thing that the Hardy County court only thing the Hardy County court had issued in its order was whether or not Hardy County had jurisdiction over that. Hardy County said, no, we don't have jurisdiction. This needs to be transferred to Palm Beach County. So when the state responded, they only responded to that issue. The sentencing transcript was not essential to that. So the second district never had that sentencing transcript. That was essential to determine the habeas corpus in this issue. But they determined it without it. It was so essential. I mean, obviously, we have it in front of us now, and we know that trial court's oral pronouncement was clear.
So you would say that if this had come up by what would have been the method? You said the correct method when after the time, the court lacks jurisdiction, and there is discovered to the defendant's advantage a discrepancy between the written sentence and the oral pronouncement. What law do we have that says that I mean, the law that says the oral pronouncement prevails are those cases that say that you can't create a harsher sentence by the entry of a written sentence if it wasn't orally pronounced. But the reverse issue, which is if a mistake is made and gives the defendant credit, like as was given on page 2 of the sentencing order, that inures to the defendant's advantage, what law says that can be taken away?
Well, right now in that order, we don't have any advantage because that order is internally inconsistent.
But I'm asking you that question. In other words, let's assume that what has happened is, and there's no internal inconsistency, there's an error in the written document that gives the defendant more credit than was intended.
Well,
don't you agree that once that credit is given, that there is ample case law that it cannot be taken away to the defendant's disadvantage?
Both yes and no. No, if it is a Scrivener's error. It depends on what type of error. If it is a Scrivener's error, it can be changed. If it is more than a Scrivener's error, it could not be changed. Does that make sense? A simple
depends what a Scrivener's error is.
Right, and that was explained in Ashley.
Scrivener's error involved in this case because the document is internally inconsistent. It can't be reconciled. So
it could not be
some
reconciled.
Entry on the document had to be a Scrivener's error.
Yes, and that would be the second page as the judge reflected in her amended order. Although void, she did reflect that in her amended order. So we know that now that the second page was the Scrivener's error and we have the oral pronouncement which reflects what the judge did in her amended order. So, we now know all of that information in hindsight.
But the fundamental point you're making is that's got nothing to do with the circuit court in Hardee County.
It doesn't, and it has nothing to do with what the second district has the authority to do. The second district didn't have the authority to touch the merits of this case at all, is really what the point that the state is making. All of this stuff should have been done in Palm Beach County, the 4th District Court of Appeals. In fact, as the state pointed out and as the defendant pointed out in his brief in Hardee County, he had filed a post-conviction 3850 in Palm Beach County on his credit for time served claim already before he filed his Hardee County habeas petition. So he had already attempted to raise this credit for time served claim. So
if we send this back to Palm Beach County, what happens?
Well, the state would urge that, based on Baker, and in Baker they say if the defendant had already raised a prior claim, that the appropriate thing to do is actually dismiss the petition. So
we have on the record, and nothing can be done, that a trial judge.
Well, we do have the void order issue. That issue is still out there. So the state would say, yes, on that particular void order issue only, that can be sent to Palm Beach County so the trial judge can address her void order, enter a new order to address the fact that her original sentencing order from March 2005 is internally inconsistent. That particular issue she can now deal with.
Raise any, if it's done that way, then the issues of whether double jeopardy attached or whatever can be raised at that time? Is that what you're suggesting?
Any of those issues as well. But again, any cognizable orders attached to that, void order issue.
Wasn't this issue already determined on the merits?
The credit for time served issue, yes, it was.
And it was appealed to I think it was the 4th?
It was appealed to the 4th.
And
they
the 4th
remanded it back.
And the defendant failed to appeal that?
That is correct.
So isn't that procedurally barred?
It is procedurally barred, Your Honor. The credit for time served issue, yes.
Tell me why the original order is internally inconsistent again?
Okay.
Let me grab it.
On the first page of the order, what we have is, it says, in the area, the judge wrote 5 years, 5 years, 5 years. And then under that, what the judge wrote is, further ordered that the defendant shall be allowed a total of 1,915 days of credit. So that's what the judge wrote on the first page.
Time incarcerated prior to the imposition of this sentence.
Right, and so that's a total of time from, 1994 when he was originally arrested
and
to...
the arrow is going to what?
Those arrows are... those arrows, you mean for a term of that arrow? That is for the 5 years, 5 years, 5 years, 5 years. That's showing how she figured out the sentence and all the counts.
Okay. And, so on
and then on the second page, what we have is where the box is checked, it is further ordered that the defendant be allowed 1,915 days time served between the date of arrest as a violator following a release from prison to the date of resentencing. Now, that is only for the time period where he was arrested on his violation of probation to the date that he was sentenced.
And this said, and the other page says, credit for time incarcerated prior to the imposition of this sentence.
Now, the defendant in this case had already served a 5-year prison term before he was arrested on his violation of probation. So there's no way he could have 1,915 days if he had served a 5-year prison term before his date, because those two numbers cannot be consistent. Because that would mean that the 1,915 days in total cannot also be 1,915 days of time that he had served after he was arrested on his violation of probation. Those two numbers are inconsistent. So you can't have those two. It's because you have 1,800 plus days is how much time you would serve on a 5-year prison sentence. So if you figure that, so that's how much of the 1,915 days was his prior prison sentence. He served, I can't remember how many days prior to, from his date of arrest on the violation of probation to his date of being sentenced, but it was less than a year. So if that puts that into context, why the Department of Corrections was so confused about where this 1,915...
Whenever I see these kinds of sentencing schemes, it always gives me some concern, because you end up with, what was there, 7 or 5 different sentences here. Well, originally there were a number of them. Mm-hmm. Some of them he gets incarceration for, and the others he gets probation for. And it is always interesting to me how you can just suspend, I guess, the other ones until it's probation time. Mm-hmm. And so that's why I think you always end up with these problems with how much credit you're going to give them, because for all intents and purposes, they're in jail or in prison. They've been convicted of those crimes, and so don't they get some credit for these other crimes that they're going to later be on probation for, because they're in jail and they've been convicted?
And he absolutely got his credit, because, like I said, he got his 1,800 plus days for his 5 years, and he got his time that he had served prior to being incarcerated, his jail time for that, and he got his jail time on the time he got after when he got arrested for his violation.
When does the record show that he first learned of the amended sentence?
There's not an exact time period. What the defendant's claim is that he had gotten requested documents from the Department of Corrections, and that when he received those documents, that's when he received the memo from the Department of Corrections and found this out.
Because when you said that it had already been adjudicated,
Mm-hmm.
when it was sent back, it was apparently no hearing, and they said he was then supporting his claim that the 950-day credit was to be applied to each count, not the total sentence. Mm-hmm. So we don't know if he was talking about page 1 or page 2 of the order, or if the amended order was even brought up at that time.
The amended order was not. He's always made it on the original 2005.
Okay, so therefore, it may not have ever been before the trial court.
like I said, the void order issue was not.
Okay,
and
so
that's why I wanted to be clear on that.
Perry asked you that question.
The credit for time served issue has been.
But he didn't know about the amended order until 2007.
The credit for time served issue is about the original order, not the amended order. I want to be clear on that. The credit for time served issue is about the original order. The amended order issues are about it being void, about it being double jeopardy, those are the amended order issues. The credit for time served issue is on the original order. That issue has already been adjudicated by the post-conviction motion.
Well, and has it been adjudicated in a way that's consistent with the amended order?
Yes.
Okay.
Yes, it has. In fact, when it was adjudicated...
So this issue about the amended order not being valid, that's really kind of no real significance.
It is of no real significance. And I'd like to point that out because it also is also important for what the Second District did, because they believed that they had authority over this case because it was void. The amended order was void. Well, okay, that even if that they did have authority over it for it being void, they still couldn't look at this order and analyze it because they didn't have authority to analyze a non-void order. That is clearly not their authority in habeas, because if at anything, the cases that they have cited, T.O. and Murray, which are pretrial cases and state stillage is not appropriate for post-trial issues, does not give them authority over non-void issues. So, I mean, the Second District in this case surpassed their authority on multiple levels. And so the state believes that what this court can do to clear up future error, you had brought up, Justice Parenti, you had brought up the issue of, specifically the issue of manifest injustice. Some clarity on the issue of manifest injustice, that when an issue is brought up on manifest injustice, that doesn't mean that a defendant gets a chance at habeas relief. It would mean that they get maybe a successive motion in post-conviction. And there seems to be some confusion out there about what exactly manifest injustice provides a defendant. So that would be one area of clarification that this court could provide.
The manifest injustice claim relates to the order, something that the sentencing court has done, not something that the Department of Corrections has done.
Correct.
And therefore, it should be something that would go back to the circuit in which the sentence was imposed.
Correct. And I think the clarity on that would then provide defendants the ability to understand where to correctly file their claims of manifest injustice. They don't then get the habeas claim, they would then get the post-conviction claim. So,
and with that, I believe you have used more than your time.
Okay.
Thank you.
Thank you, Your Honor.
Good morning. May it please the court. My name is David Luck, and along with Mr. John Blue and Mr. Andrew Manco, I represent the respondent in this matter, Warren Stang, who's currently incarcerated in Dade City. Your Honors, this is admittedly...
How did you get appointed to this case?
Your Honor, I received an email from Mr. Brian Gowdy notifying that the court needed counsel to volunteer to represent Mr. Stang, and I beat everyone else to the punch. So, admittedly, this is a unique case, and just to clarify before I forget, and to answer Justice Perry's question, this issue has not previously been resolved by the Rule 3.850 motion because, in response to Mr. Stang's Rule 3.850 motion, the state relied upon the original written sentence and never acknowledged that there was an amended sentence in this case, and the trial court, which was the same trial judge who entered the original written sentence, also adopted the state's response and reconfirmed the validity.
But there is no amended sentence. That's a void order. Isn't that your position?
Correct, Your Honor.
So in effect, that doesn't exist.
Correct. However, the state...
So how is what you're saying make a difference?
Your Honor, the state has had 5 years to raise an inconsistency between the oral impositions, plural, of sentence, which we contend are themselves internally inconsistent, and the sentence as written. At least 4 junctures, the state never raised this issue. They never raised this issue in the 3.850 response. They never even acknowledged that the amended sentence existed. They never raised an oral inconsistency in either of the previous habeas petitions, one of which was denied without prejudice, and the state contended in their brief incorrectly was a procedural bar. It's not a procedural bar. It was denied without prejudice because the Department of Corrections misled Mr. Stang into believing that he fully exhausted his administrative remedies, which he had not. So what we have here is really
in those prior instances, was the same issue presented? Or was it on entirely something different?
Your Honor, we don't have that information directly in the record because the record doesn't actually contain Mr. Stang's 3.850 motion, but the second DCA's decision indicates that Mr. Stang's 3.850 motion sought to have his jail credit applied as it was stated in the March 30th, 2005 written sentence. However, in denying the 3850 motion, the trial court adopted the state's response, and the state was relying upon the original written sentence. Now, Your Honor,
this case seems to break down then to a procedural posture to me of how did the second district get authority to do what it did? And so
right.
You could address that.
Yes, Your Honor, and that also brings up the jurisdictional issue. The reason the second district addressed this case is that it thought it was dealing with an expired sentence. And at least according to the Florida Department of Corrections, the sentence, if amended, including the second page of the written sentence, would have expired. And there's Florida precedent, most recently from the First District Court of Appeal in 2009, a case called Santana versus Henry, that states that when an incarcerated individual is seeking immediate release based upon an expired sentence, habeas corpus is an appropriate procedural mechanism. There's also the decision of Kirkman versus Wainwright from the 5th DCA in 1985. There's Ned versus Wainwright from the 1st DCA in 1984. And there's Diggs versus Florida Department of Corrections, which is also from the 1st District Court of Appeal. Now, the state attempts to distinguish most of these decisions by contending that they involve situations where a sentence is expired and the Department of Corrections simply isn't carrying out the sentence properly, and it doesn't involve a situation where the trial court has done something improper. But the decisions as written don't indicate a distinction. If the sentence as written is expired, the state has never filed a proper motion alleging any inconsistency between an oral imposition and a written sentence. The only logical thing for a defendant to do, or a habeas petitioner rather, to do in the position of my client is to file a habeas petition because he believes his sentence is expired. And that segues into the jurisdictional issue, Your Honor. Baker versus State involved true collateral attacks. Actually, three original habeas petitions were filed in this court. Petitioner Baker alleged that jurors were not properly qualified in his case. Petitioner Brooks alleged that the jury was not properly sworn. And Petitioner Sly alleged conflict with his counsel rendered his guilty plea involuntary. None of those instances involve an expired sentence. And looking at conflict jurisdiction, as Your Honors know, you have to look at the four corners of the decision below. The second DCA's decision below indicates that we're dealing with an expired sentence. It doesn't indicate any inconsistency with an oral imposition and a written sentence, which was raised for the first time before the Florida Supreme Court. With regard to State versus McBride, that case involved Rule 3800 motions and procedural bars to Rule 3800 motions. First of all, this case, as it is appearing before this court, does not involve a Rule 3800 motion. Second, there is no applicable procedural bar because with regard to the Rule 3850 motion, again, the trial court reconfirmed the validity of the March 30th written sentence by adopting the state's response, which attached sentence. With regard to the Okeechobee habeas petition, it was denied without prejudice so that Mr. Stang could fully exhaust his administrative remedies and file another habeas petition. And the direct appeal contentions are meritless as well because Mr. Stang was unaware that there was an amended sentence at that time. And
let me ask you about that one on the direct appeal. If Mr. Stang and his lawyer thought that the sentence provided for immediate release,
wouldn't have been any need for an appeal. I mean, so there's something about that if we go back and say, well, it's the original sentence that prevails.
Correct.
That was, and if the idea was that there was a question as to whether the first page conflicted with the second, why wasn't that already apparent at the time that the direct appeal was filed? Because that's the sentence that they were operating under.
Your Honor, the only response that I can provide is not record-based, and that's what my client has told me in my interview with him, which is he was represented by counsel at that time and he was not able to articulate his own arguments. All of this involving his challenges to the sentence in terms of it being expired have been conducted pro se. He's done all this on his own.
Let's assume that we strip away the idea of this void act by the trial judge, which the state has conceded, and we go back to the actual sentence. Do you agree there is an inconsistency or an ambiguity between page 1 and 2?
I think, in all fairness to the court, I would have to agree that there is a possible inconsistency. However, the written sentence has never been properly amended through any procedural mechanism, either a 3800A motion, a 3800B motion, or there are decisions recognizing the trial court's inherent authority to correct clerical errors in their sentences, but all those decisions involve adequate due process protection.
So if we were to quash the second district, I'm assuming if there's a jurisdictional basis, to say that there really is a question as to whether this is truly an expired sentence or it's a clerical error, would it then go back to the second district or to the trial court? What would be the next step?
I think, Your Honors, if you do not view the sentence as expired and permit Mr. Stang to be immediately released, I think the most analogous case is a decision called Jory v. State from the 5th District Court of Appeal. The site is 699 Southern 2nd 820. In that case, the trial court amended sentences while the defendant's direct appeal was pending. Then the 5th District Court of Appeals struck those as void, and because the trial court's prior sentences were arguably inconsistent and confusing, the 5th DCA vacated all of the prior sentences in the case, sent it back down to the trial court for a new sentencing proceeding. At a minimum, if Mr. Stang is not entitled to immediate release because of the entire lack of due process involved over the last 5-year period, he should at least be entitled to notice and an opportunity to be heard in a new sentencing proceeding, preferably before a different judge.
But what would be the basis for giving him a new sentencing proceeding? In other words, if you throw out the amended sentence, whichever, and you just rely on this sentence, isn't there? And again, I realize this is, you're here as both his counsel as an officer of the court. Is there case law that says when there's an ambiguity in a written sentence, where at least the second page totally inures to the benefit of the defendant, that the defendant should get the benefit of the ambiguity?
I'm not aware of any Florida precedent that's directly on point, but the state and the Department of Corrections both contend that the oral imposition, and they use most of the time they use the terms in the singular form, but it's really plural. There are 2 oral impositions. They believe that it's clear what the trial court intended to do based upon those oral impositions. However, if you look at, and this is on page 118 of the Department of Corrections record supplement, the first oral imposition of sentence, arguably and probably based upon our reading, only adds up to 22 years of incarceration. And the court doesn't...
The oral pronouncement clearly did not intend to send him home, did they?
Your Honor, the trial court does state...
Because of the ambiguities in the written order, he would be released immediately. That obviously was not the intent by the oral pronouncement of the court. He said, you're a con artist, you've done it this time, I'm sentencing you to. And he did it twice, to 27 years, credit for time served.
That's correct, Your Honor. However, if there is an inconsistency between the written sentence and the oral imposition of sentence, the burden in this case would be on the state to seek a correction through a proper procedural mechanism. And again, That never occurred here because the sentence was amended ex parte with no notice to anyone.
Granted, I agree.
So here we're left with the written sentence, and because the state has never previously raised an oral imposition inconsistency argument, it shouldn't be able to do it for the first time.
Well, they would have to. I mean, the bottom line is that the only way that the state could get any relief would be to show that it is a Scrivener's error. Correct.
They would have to show that there's a clerical error in the written sentence and that the trial court's oral imposition should control, notwithstanding the fact that the trial court has not previously entered another valid sentence.
We have case law that says, I'm a little concerned. Again, I want to be fair to both sides here, but that if the sentence is already, the time for appeal has run, that the state does not have the ability to seek an amendment that will prejudice the defendant. I don't know case law that, allows that. I thought the case law ran contrary, that if there is an erroneous award of credit, the defendant gets that benefit.
Well, did the trial judge write this order?
I believe so, Your Honor. The
clerk wrote the order.
It's not clear from the record.
It's a form. I've looked at it. It's a form, and she checked the second page, cleared the first page. Had she not done anything on the second page, we wouldn't be here, right? The clerk, it's the clerk's function is to check those boxes, and the clerk made a Scrivener's error.
I'll have to take your word for that, Your Honor. I have not previously been a trial judge such as yourself, but if you're telling me that the clerk is the individual who fills out the sentencing form, then I'll take your word for that. But again, that would just go back to the point that if there is an error in the written sentence, it's the state's burden then to try and seek a correction. And
was this correction done before the actual direct appeal was over?
Yes, it was, Your Honor. Mr. Stang's direct appeal in the 4th DCA case number 051556 was pending from April 21st, 2005 until November 3rd, 2006. The nunc-pro-tunc amended sentence was entered on June 7th, 2005.
But on a direct appeal, the defendant appeals the judgment and sentence. Does the state, I don't recall, if the state sees a sentencing order like this and there is some problem with it, can the state cross-appeal the impropriety of the sentencing order?
Well, Your Honor, they could even file a 3800B2 motion while the appeal is pending. Florida Rule of Appellate Procedure 9600D provides the state the ability, even while the defendant's direct appeal is pending, to file a 3000B2 motion to correct a Scrivener's error.
But isn't it only if it's going to benefit the defendant?
No, Your Honor. It says if it benefits the defendant and it's disjunctive, or to correct a Scrivener's error.
So if they recognize there's an error, which it was the first sentence was before there, and they don't do that in that time period, wouldn't that be waived then by the state?
Well, it's our contention that it's waived. However, the state in its brief also makes the arguments under Williams and Ashley, two judges from this court, that the oral imposition controls over a written sentence, and that an oral imposition that conflicts with a written sentence produces a written sentence that's illegal. But both of those cases discussed that rule in the context of situations that benefited the defendant.
Right, exactly.
I'm not sure if the same reasoning, I haven't found a case, and I don't believe the state has cited a case, where the same Rule 3800A would permit the state to now.
I think that's, I was asking you a question, I don't know, you had a chance to answer it, which was if an error is made, and it inures to the benefit of the defendant, such as jail credit, an amount being wrongfully or erroneously awarded. Are there cases that say that the state, once it's given, can take it back?
I want to be entirely honest with the court. There are at least two decisions in Florida that don't say that the state has the ability to do so, but they say that the trial court has the inherent authority at any time to correct clerical errors in its sentence. The first one is a decision called Drumright from the 5th District Court of Appeal. It's a 1991 decision, 572 Southern 2nd, 1029, and a case called Carson v. State from the 2nd DCA, 1986, 49 Southern 2nd, 1236. However, in each of those decisions, the trial court did so by affording the defendant all necessary due process protections, that being procedural due process, notice and an opportunity to be heard and to participate in the resentencing process. The court didn't just receive an ex parte communication from the Department of Corrections and then enter a nunc-pro-tunc amended sentence. Those cases would still require proper due process protection, which again has not occurred in this case. Your Honors, the state treats this case as a garden variety collateral attack on a judgment of conviction and sentence. I'm not sure if it really fits within those parameters. They don't cite a case, and we haven't found a case where there is a validly entered written sentence that, according to at least the Department of Corrections, would have resulted in a potential immediate release, and then a later amended sentence that was void because it was entered without jurisdiction. None of the cases that they cite, including Baker, none of them involve that type of situation. What we're really left with are the decisions that I previously mentioned that state in Florida where you have an expired sentence, you can use habeas corpus. And again, in this case, we're dealing with a layperson, my client, who really is quite remarkable for having no legal training. And he saw these cases and he recognized that, hey, there's a written sentence in my case. The way I read it and the way the Department of Corrections reads it, it entitles me to immediate release. What does the case law say I should do? It says I should file a habeas petition. So that's what he did. The last point that I would really like to mention relates to, and I know they're not here to argue in response, so I have no objection if the state would like to bring this up in rebuttal, but the cases cited by the Department of Corrections in their amicus brief where they request the court to approve their totally informal process of contacting trial courts for amended or clarified sentences, none of them actually support what the Department of Corrections is requesting. First is the decision Henry Matter of Chapman, which is a Washington Court of Appeals, Washington State decision from 1990. In that case, Washington State's legislature recognized the potential for this type of situation to arise and provided a statute that allowed their Department of Corrections to petition an appellate court when the Department of Corrections thinks that a trial court has made a mistake in a sentence. And the statute provides, again, all necessary due process protection. That didn't occur here. Regardless of what the Department of Corrections' current practice is in terms of dealing with these situations, we know for a fact here, is conceded by the state, that no one ever provided notice to my client. The second case I want to mention is from California. Similar situation, also involves a statute that permits the Department of Corrections there to challenge a sentence that a trial court arguably entered erroneously. That case is unpublished, but it's found at 2009 Westlaw 348-9987, and it's from the Cal First District Court of Appeal. The Department of Corrections also relies on a decision called State versus Bishop, which is a Kansas Court of Appeal decision that is also unpublished. And in that case, the Department of Corrections sent a letter to the state attorney, but CC'd the trial court and prompted the state attorney to file a motion to correct an illegal sentence. Totally distinguishable from what happened here. The prosecutor wasn't even involved in amending the sentence. It was simply the Department of Corrections and the trial court clerk. And then the final decision the Department of Corrections relies upon for this request that they be able to informally contact trial courts is Wilkins L. versus Marbury, which is an unreported decision from the Seventh Circuit, the federal Seventh Circuit. There, the Federal Bureau of Prisons did not seek to amend a sentence, but merely sought to determine whether the defendant was sentenced under the federal sentencing guidelines, because there was an issue as to whether he was entitled to parole under the guideline sentencing structure. Your Honors, I see that my time is almost at an end. We would respectfully request that the court either discharge jurisdiction because there's no proper conflict in this case, or that the court approve the Second District's decision below that habeas is an appropriate mechanism to use for an expired sentence. Thank you, Your Honors.
Thank you both for your, you have exceeded, you used more than your time originally, yes. Thank you both for your arguments here today. The court will now be in recess until tomorrow morning. Please rise.
watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.